Article 11. Justifying circumstances. Number 1. Anyone who acts in defense of his person rights provided that the following circumstances concur. First, unlawful aggression. Second, reasonable necessity of the means employed to prevent or repel it. Third, lack of sufficient provocation on the part of the person defending himself. Number 2. Anyone who acts in defense of the person or rights of his spouse, ascendants, descendants, or legitimate, natural, or adopted brothers or sisters, or of his relatives by affinity in the same degrees, and those by consanguinity within the fourth civil degrees, provided that the first and second requisites prescribed in the next preceding circumstances are present, and the further requisites in case the provocation was given by the person attacked that the one making defense had no part therein. Number 3. Anyone who acts in defense of the person or rights of a stranger, provided that the first and second requisites mentioned in the first circumstance of the article are present, and that the person defending be not induced by revenge, resentment, or other evil motive. Any person, number 4, any person who, in order to avoid an evil or injury, does an act which causes damage to another, provided that the following requisites are present. First, that the evil sought to be avoided actually exists. Second, that the injury feared be greater than that done to avoid it. Third, that there be no other practical and less harmful means of preventing it. Any person who acts in the fulfillment of a duty or in the lawful exercise of a right or office. Number 6. Any person who acts in obedience to an order issued by a superior for some lawful purpose. Article 12. Circumstances which exempt from criminal liability. Number 1. An imbecile or an insane person, unless the latter has acted during a lucid interval. When the imbecile or an insane person has committed an act which the law defines as a felony, the court shall order his confinement in one of the hospitals or asylums established for persons thus afflicted, which he shall not be permitted to leave without first obtaining the permission of the same court. Number 2. A person under 9 years of age. Number 3. A person over 9 years of age and under 15, unless he has acted with discernment, in which case such minor shall be proceeded against in accordance with the provisions of Article 80 of this Code. When such minor is adjudged to be criminally responsible, the court, in conformity with the provisions of this and the preceding paragraph, shall commit him to the care and custody of his family, who shall be charged with his surveillance and education. Otherwise, he shall be committed to the care of some institution or person mentioned in said Article 80. Number 4. Any person who, while performing a lawful act with due care, causes an injury by mere accident without fault or intention of causing it. Number 5. Any person who acts under the compulsion of an irresistible force. Number 6. Any person who acts under the impulse of an uncontrollable fear of an equal or greater injury. Any person who fails to perform an act required by law when prevented by some lawful or insuperable cause. Article 13. Mitigating circumstances. Number 1. Those mentioned in the preceding chapter, when all the requisites necessary to justify the act or to exempt from criminal liability liability in the respective cases are not attendant. That the offender is under 18 years of age or over 70 years in the case of the minor, he shall be proceeded against in accordance with the provisions of Article 80. That the offender had no intention to commit so grave a wrong as that committed. That sufficient provocation or threat on the part of the offended party immediately preceded the act. That the act was committed in the immediate vindication of a grave offense to the one committing the felony, his spouse, ascendants, descendants, legitimate, natural, or adopted brothers or sisters, or relatives by affinity within the same degrees. Number 6. That of having acted upon an impulse so powerful as naturally to have produced passion or obfuscation. Number 7. That the offender had voluntarily surrendered himself to a person in authority or his agents, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. Number 8. That the offender is deaf or dumb, blind, or otherwise suffering some physical defect which thus restrict his means of action, defense, or communication with his fellow beings. Number 9. Such illness of the offender as would diminish the exercise of the will power of the offender without, however, depriving him of consciousness of his acts. 10. And finally, any other circumstance of a similar nature and analogous to those above mentioned. Article 14. Aggravating circumstances. Number 1. That advantage be taken by the offender of his public position. Number 2. That the crime be committed in contempt of or with insult to the public authorities. Number 3. That the act be committed with insult or in disregard of the respect due to the offended party on account of his rank, age, or sex, that it be committed in the dwelling of the offended party, if the latter has not given provocation. That the act be committed with abuse of confidence or abuse ungratefulness. Number 5. That the crime be committed in the palace of the chief executive or in the presence of or where public authorities are engaged in the discharge of their duties or in a place dedicated to religious worship. Number 6. That a crime be committed in the night time or in an uninhabited place or by a band, whenever such circumstances may facilitate the commission of the offense. Whenever more than 3 armed malefactors shall have acted together in the commission of an offense, it shall be deemed to have been committed by a band. Number 7. That a crime be committed on the occasion of conflagration, shipwreck, earthquake, epidemic, or other calamity or misfortune. Number 8. That a crime be committed with the aid of armed men or persons who ensure or afford impunity. Number 9. That the accused is a recidivist. A recidivist is one who, at the time of his trial for one crime, shall have been previously convicted by final judgment of another crime embraced in the same title of this code. Number 10. That the offender has been previously punished for an offense to which the law attaches an equal or greater penalty or for 2 or more crimes to which it attaches a lighter penalty. Number 11, that a crime be committed in consideration of a prize, reward, or promise. Number 12, that a crime be committed by means of inundation, fire, poison, explosion, stranding of a vessel, or intentional damage thereto, derailment of a locomotive, or by the use of any other artifice involving great waste and ruin. Number 13, that the act be committed with evident premeditation. Number 14, the craft, fraud, or disguise be employed. 15, that advantage be taken of superior strength or means be employed to weaken the defense. 16, that the act be committed with treachery or alevosía. There is a treachery when the offender commits any of the crimes against the person, employing means, methods, or forms in the execution thereof, which tend directly and especially to ensure its execution without risk to himself arising from the defense which the offended party might make. 17. That means be employed or circumstances brought about which add ignominy to the natural effect of the act. 18. That a crime be committed after an unlawful entry. There is unlawful entry when an entrance is effected by a way not intended for the purpose. 19. That as a means to the commission of a crime, a wall, roof, floor, door, or window be broken. That the crime be committed with the aid of person under 15 years of age or by means of motor vehicles, airship, or other similar means. 21. That the wrong done in the commission of the crime be deliberately augmented by causing other wrong not necessary for its commission. Thank you.